Committee on House Administration for purposes of today's hearing titled Preventing Sexual Harassment in the Workplace. The hearing record will remain open for 5 legislative days so members may submit any materials they wish to be included. A quorum is present, so we may proceed. At the outset, I ask for unanimous consent that Committee on Ethics Chairwoman Susan Brooks and Ranking Member Ted Deutsch be afforded the opportunity to sit on the dais and question all of our witnesses today. Without objection, that's approved. I also ask for unanimous consent that Representative Speier be afforded the opportunity to sit on the dais and question our second panel of witnesses. Without objection, so ordered. I'd like to thank all of our witnesses for taking time out of their busy schedule to be with us today on this very serious issue. And I commend Speaker Ryan for bringing this important issue to the forefront and for tasking this committee to undertake a comprehensive review. Today's hearing is a critical part of that review process. First and foremost, let me say that there is no place for sexual harassment in our society, period, and especially in Congress. This is an extremely important topic, and it will take all of us working together to effectively address this issue. I believe as members of Congress, we must hold ourselves to an even higher standard, a standard that demonstrates that we are worthy of the trust placed in us by our constituents and the American people. The disturbing accounts of sexual harassment experienced by current and former members, including one of our witnesses today, revealed that sexual harassment is a serious problem in our society, and Congress is not immune from this issue. It's no secret the culture on Capitol Hill is unique. While there are 441 employing offices in the House among members and representatives, we should all share the common goal of creating safe and effective work environments that are productive, collegial, and responsive to the needs of our staff, constituents, and the public. The personal accounts described by our current and former colleagues and staff suggest that not every office is achieving this goal. These accounts dictate the need for a comprehensive review of the House's policies and procedures, as well as the resources available as it relates to sexual harassment in the workplace. Currently, sexual harassment awareness training is not mandatory for members and staff. There is also concern that victims of sexual harassment are not aware of the resources available to them. Some have criticized the process that currently exists to adjudicate claims of sexual harassment. Today we'll hear from 2 members, one of whom was a victim of sexual harassment while a congressional staffer, and the other who specialized in employment discrimination litigation, including sexual harassment cases, before his election to Congress. In addition, we'll hear from representatives of the Office of Compliance and the Office of House Employment Counsel, 2 entities that are responsible for providing training and resources to members and staff, among other services. The Office of Compliance is an independent agency established by the Congressional Accountability Act to administer and enforce the provisions of the Act. While the Office of Compliance is responsible for educating and training members, staff, and the public on workplace issues, there are individuals like Representative Speier and Holmes Norton who have spoken publicly about the need for the Office of Compliance to do more. The Office of House Employment Counsel, located within the Office of the Clerk, provides training and resources for members and chiefs of staff, as well as training for the entire office. In addition, the Office of House Employment Counsel represents employers in the Office of Compliance proceedings. Several bills and resolutions have been introduced in the House seeking changes to the process, many of which involve making training mandatory for all members and staff. According to the Office of Compliance, and I quote, "It is widely acknowledged that anti-discrimination and anti-retaliation training for employees provides many benefits to the workplace. Education directly impacts employee behavior. A comprehensive training program continues to be the most effective investment an organization can make in reducing complaints and creating a more productive workforce." Now, I believe we need mandatory training. I think probably everyone here will agree, as well as a more organized and comprehensive approach to address sexual harassment in the congressional workplace. As I said at the beginning of my remarks, The hearing is just the first step in our review. I look forward to hearing from each of our witnesses today on both panels. Mr. Brady, I'll now recognize for the purposes of an opening statement.
Thank you, Mr. Chairman. And Mr. Chairman, thank you for calling this hearing today. The congressional workplace should have zero tolerance for sexual harassment and any kind of discrimination. That's why I was pleased to be one of the first sponsors of the Congresswoman from California's resolution. Congresswoman Speier's courage and her determination deserve the respect and attention of members of Congress, and her plan deserves action. I thank her very much for being here today. The Congresswoman's proposal will require mandatory training for members and staff. It will also require the Office of Compliance to get back to us very quickly on additional improvements to their program. This bipartisan legislation is the first step, and the House should pass it immediately. I want to emphasize that this should be just a first step. I hope we can also look at ways to strengthen and clarify our dispute resolution process and other ways to support the Office of Compliance, including with additional money. I have supported additional appropriations for the Office of Compliance every day they have asked, and it's an important agency worthy of our support. I thank our witnesses for being here today, and I am glad that Mrs. Speier will be joining us on the dais after a panel discussion. I'm also pleased the ranking member of the Ethics Committee, Mr. Deutsch, will try to join us, since the Ethics Committee will have a role to play in holding all of us to the highest conduct. Again, thank you, Mr. Chairman, and I yield back the balance of my time and look forward to our witnesses' testimony.
Thank you, Mr. Brady. I'll now recognize Barbara Comstock for the purposes of an opening statement.
Thank you, Mr. Chairman. In recent weeks, sexual harassment and sexual violence by powerful men has come to light as never before. People have named names, and there is a renewed recognition, rightfully, of this problem and the need for change of culture that looks the other way because of who the offenders are. Whether it's Bill Cosby, Harvey Weinstein, Bill O'Reilly, Mark Halperin, Roger Ailes, Kevin Spacey, or one of our own, it's time to say no more. I've been an intern in this body. I've been a staffer, like our witnesses here today. I've been a counsel on committee, and now as a member. So I particularly appreciate the opportunity for this hearing today. And I appreciate that we have already committed to mandatory sexual harassment training for all of the members, I emphasize members, and staff. And I think we do have a consensus of need to have improved training materials and practices, making sure we are getting better reporting, a better response, feedback loop, really knowing what's going on with surveys or other type of things, but most importantly, to protect the victims. And I know we'll be exploring that in weeks to come. We need to know more of examples of what is actually happening and making it easier for the victims to come forward. We know there are still many who are in the shadows or forgotten because their situations may have happened at a time where less attention was paid. Last night I had the opportunity to talk to Dorina Bertucci, who in 1988 filed the Hill's first successful harassment complaint 30 years ago against Representative Jim Bates of California. In a recent interview and roll call, and I hope you've seen that if you haven't read it, she noted how she had many women in her office who had the same experience, but only she and one other came forward. But she felt it was so important. In speaking with her and seeing how brave she had been, because this was 30 years ago, you could hear the pain still in her voice in telling that story, but you could also hear the strength and the resolve. And women need to hear that and know that we'll be there to back them up. We know, and I think it's important we name names. I mean, the Hollywood rumors, all these things, people had heard these rumors for years. One of Roger Ailes' victims was a friend of mine. I never knew this had been something that had happened to her until I read her story in the New York Times. And I knew it was true because I knew her, talked to her about it after. But I was here in the time of Bob Packwood, Charlie Wilson. I think of some of the things, Charlie Wilson said, you could teach him to type, but you can't teach him to grow, I'll say breasts. He used a more vulgar term. And I wanted to close with something that I just had somebody tell me recently. This is about a member who is here now. I don't know who it is, but somebody who I trust told me this situation. This member asked a staffer to bring them over some materials to their residence. And the young staffer, it was a young woman, went there and was greeted with a member in a towel. It was a male, who then invited her in. At that point, he decided to expose himself. She left, and then she quit her job. She left, she found another job. But that kind of situation, what are we doing here for women right now who are dealing with somebody like that? So this is really a much more complex situation than I think we need to have more training, know about the violence that we're seeing in some of these that are criminal. Like we get people into the criminal system when you have a crime. I would argue that probably is a crime in that situation. And have people know that. And then that we have a much better process so that that person doesn't have to give up her career. I was listening to one of the victims of Mark Halperin, and she was talking about how she was very strong, left, didn't do anything, but there were other women who left their desired profession altogether because of what had happened, and we can't have that happen. So, Mr. Chairman, I really appreciate your giving us this opportunity, and I know we're going to have more hearings. I think it's important that we do that and that we hear more from the people who have been out in the shadows. Thank you.
The gentlelady yields back. The chair will now recognize Congresswoman Zoe Lofton for purposes of an opening statement.
Thank you, Mr. Chairman. There's no question that sexual harassment in the workplace, including Congress, must be addressed. And I want to thank Chairman Harper and Ranking Member Brady for today's hearing on this important subject. And I want to thank the witnesses, Congressman Bradley Byrne and Representative Jackie Speier, for coming before us today to help us examine how we can make improvements to our policies and procedures for preventing sexual harassment, as well as for handling complaints once they're filed. Now, Representative Speier's resolution, the CEASE Act, calling for mandatory sexual harassment training is a step in the right direction, but as she and I have discussed, it's not the end. We need to examine dispute processes at the Office of Compliance to make sure victims can expeditiously have their grievances heard. And I think this is especially important because sexual harassment is often about power. It's not just about sex, it's about abuse of power. And our hardworking staffs and others need to have an advocate just as powerful on their behalf. Mandatory training is long overdue. The Office of Compliance has been recommending it for 20 years, and the Senate just unanimously passed a resolution mandating it last week. Seems to me if Senator Ted Cruz and Elizabeth Warren can agree, we should also be able to agree on our side of the building. The online training is just a small start, but study after study shows that in-person training is where you have the most progress in changing workforce behavior. We need to do a better job of advertising the resources that are available, but we also need improvements in the process once people do make a complaint. I just want to make a special word about Congresswoman Jackie Speier. Years ago, she and I were staff compatriots. We worked on the Hill at the same time. She worked for Congressman Leo Ryan from the Mid-Peninsula, and I worked for Congressman Don Edwards, just south of that district. It was a wild and crazy time in many ways in our history. We had the impeachment of Richard Nixon, the war and the disruption and the like. But one of the things that Jackie has talked about now, and I give her so much credit, is the assault that she suffered. I think it is so important that she had the courage and the grace and dignity and grit to speak up about what happened to her. And I know that that has encouraged other people to step forward and take art and know that they can speak up too. So I just want to thank Jackie for being here today, for the lead that she has taken on this issue and so many others. She's a great lawyer, a terrific leader, and not afraid of a darn thing. So thank you, Jackie, Congressman Byrne, and I yield back the balance of my time.
Gentlelady yields back. Anyone else on Republican side wishing to be recognized for an opening statement will recognize Ms. Brooks for 5 minutes for an opening.
Thank you, Chairman Harper and Ranking Member Brady. As Chairwoman of the House Ethics Committee, I'm really very pleased to be a part of this hearing today. We know in the House Ethics Committee that the House does have problems with addressing both reported and unreported sexual harassment, as just described by Representative Comstock. And the House Ethics Committee is committed to working with your committee to eliminate harassment that occurs through ensuring that our members and staff are trained and have better training. And we need to ensure that we are protecting the victims of harassment when it does occur. Sexual harassment is strictly prohibited by our Code of Official Conduct. Let me repeat that. Sexual harassment is strictly prohibited by the House's Code of Official Conduct, and something that the House Ethics Committee takes very seriously. For background, at the House Ethics Committee, we have two separate functions as they relate to sexual harassment. First, we have an Advice and Education Division. The attorneys in Advice and Education are trained when approached with a harassment issue to advise the person seeking advice to contact Office of Compliance. These discussions with our attorneys on our committee are strictly confidential, so I cannot report on the number of harassment instances raised with the committee. But I can report that the advice given is to educate the advice seeker on their options. The second function of our committee is to conduct investigations when allegations are made. And should someone be interested in initiating an investigation, they can contact the House Ethics Committee Investigation Division. The committee and I personally share this committee's goal of protecting victims of harassment. I look forward to learning from this hearing ways we can improve the House generally and how we can ensure that we take the lessons learned from today's hearing and improve the House Ethics Committee processes as well. And in closing, I would like to just commend the three female members here who've just shared, and as we've learned, all started as staffers. And it's very important, and I'm just pleased to be a part of this today. I was not a staffer here on the Hill, had never worked on the Hill prior to coming to Congress, but I think it's very powerful that the three of you who are here in many ways representing House staff and now as strong voices on behalf of not only your districts, but on behalf of the country as members. So thank you, and I yield back.
Congresswoman Brooks yields back. The chair will now recognize the gentleman from Maryland, Mr. Raskin, for the purposes of an opening statement.
Mr. Chairman and Ranking Member Brady, thank you very much for calling this hearing, and I also want to thank our distinguished witnesses for their leadership and their perseverance in dealing with this issue. The nation is in an uproar today over sexual assault and sexual harassment. From the studios of liberal Hollywood to the studios of Fox News, from Wall Street to Alabama, there is a tectonic shift taking place in women's unwillingness to put up with what prior generations of women were often forced to accept as business as usual. And I believe the public generally has seen enough too and wants action. In Congress, we must be leaders in changing a culture of sexual harassment and assault, not just by what we say in our legislation, but by what we do in our own workplace. Justice Brandeis once said, "Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example." Mr. Chairman, sexual harassment at work is a pervasive problem that's been documented. The EEOC estimated that anywhere from 25% to 85% of women have experienced sexual harassment in the workplace. And let's be clear that it is illegal, whether it takes the form of quid pro quo, sexual harassment, or hostile workplace environment harassment. It constitutes sex discrimination, and it degrades the professional status and social position of women. To think that this body is somehow immune from sexual harassment and abuse of women would be naive at best. At last count, more than 1,500 former staffers signed a petition directly calling on us to reform policies aimed at preventing sexual harassment and adjudicating complaints. My chief of staff, Julie Tagan, who has spent most of her career on Capitol Hill, says she does not know a single woman in her age group who has not experienced inappropriate conduct in the workplace. As businesses across the country face their responsibilities for creating harassment-free workplaces, we must do our own part and lead by example in the public sector. A critical first step is requiring annual mandatory sexual harassment prevention and response training for members of Congress and staffers alike, just as we require ethics and cybersecurity training. I am a proud co-sponsor of Representative Speier's cease resolution, House Resolution 604, the Congressional Education About Sexual Harassment Eradication Resolution. And I would urge the House to quickly move to adopt this measure as the Senate did last week. Although this is an important place to start, mandating annual sexual harassment training is not sufficient. We must examine existing dispute resolution processes, which recent incidents suggest may be acting still as a deterrent to reporting and resolving problems. I'm eager to hear from our witnesses today on what more can be done, and I understand that there are multiple proposals that have been put on the table aimed at encouraging reporting, soliciting feedback, promoting a healthy workplace environment, and protecting staffers against retaliation. I'm eager to learn how we can work together in a completely bipartisan way, Mr. Chairman, to create a workplace safe for all of our employees and that all Americans can be proud of. Thank you, and I look forward to the testimony today.
Gentleman from Maryland yields back. I'd now like to introduce our witnesses on our first panel. Representative Jackie Speier represents California's 14th Congressional District. She serves on the House Committee on Armed Services as the ranking member of the Subcommittee on Military Personnel and on the House Permanent Select Committee on Intelligence. She received her BA in Political Science from the University of California, Davis, and a JD from UC Hastings College of the Law. Representative Speier has been and continues to be a tireless advocate for women's rights. We appreciate her efforts in raising awareness of sexual harassment and being with us today. Representative Bradley Byrne represents Alabama's 1st Congressional District. In Congress, Representative Byrne serves on the House Committee on Armed Services as well as the Education and Workforce Committee. After completing his undergraduate studies at Duke University, Representative Byrne received his law degree from the University of Alabama School of Law. He practiced labor and employment law in Alabama for over 30 years. During Representative Byrne's practice, he advised multiple businesses on harassment policies, protocol, and procedures, and litigated numerous employment cases. He also has overseen multiple sexual harassment investigations over his many years of practice. So Representatives Speier and Byrne, the committee has received your written testimony. You'll now each be given 5 minutes to present a summary of that submission. And to help you keep time, as you've done on the other end, you know how it works. 5 minutes, with 1 minute to go, it'll go yellow. With time up, it'll go red. And we certainly want to thank both of you for this time. So the chair will now recognize Representative Speier for 5 minutes for her summary.
Chairman Harper, Ranking Member Brady, members of the committee, thank you so much for the opportunity to speak to you. And let me begin by saying how impressed I am with the seriousness with which you are undertaking this issue. It is complex, and it will be at times uncomfortable to deal with it. It's important to note that 2 out of 3 sexual assaults go unreported in this country. And oftentimes, sexual harassment leads to sexual assault. Since I shared my own story on #MeToo Congress, I have had numerous meetings and phone calls with staff members, both present and former, women and men who have been subjected to this inexcusable and oftentimes illegal behavior. In fact, there are 2 members of Congress, Republican and Democrat, right now, who serve, who have been subject to review or not have been subject to review, but have engaged in sexual harassment. These harasser propositions such as, are you going to be a good girl, to perpetrators exposing their genitals, to victims having their private parts grabbed on the House floor. All they ask in return as staff members is to be able to work in a hostile-free work environment. They want the system fixed and the perpetrators held accountable. I've been working on this issue since 2014 and believe there are 3 steps Congress needs to take to fix the egregious and sometimes illegal behavior. The first step is to require sexual harassment prevention and response training every year for both members and staff, just like ethics and cybersecurity training. The existing Office of compliance online training model is a start, as some of you have pointed out, but it is not adequate. Research has found that effective training requires in-person, interactive instruction and dialogue. A simple change to the House rules will achieve this result, and there's already legislation co-authored by many of you, H.R. 604. And I will give a special thanks to Ranking Member Brady, Representatives Costello, Palinquin, Lofgren, and Raskin for their co-leadership on this issue. Second, we can fix what we don't know. In my experience working on sexual harassment and sexual violence on college campuses, in academia, and in our military, climate surveys are conducted regularly and are key to recognizing the scope of the problem and to evaluating the effectiveness of reforms. That's why Congress should institute a congressional climate survey every 2 years. Third, we must reform the broken dispute resolution system. The present system may have been okay in the dark ages. It is not appropriate for the 21st century. Under the current process, as you see on the monitor, congressional employees are at best unaware or confused, and at worst are utterly betrayed. This flow chart shows the current process. First, you report the incident to the OC. You then have mandatory counseling for 30 days. After that, you are required, and I underscore required, to sign a non-disclosure agreement before you even begin mediation. You then have mandatory mediation for 30 days. Additionally, the harasser and the member's office are represented by House of Representatives counsel. Now listen, how does that compute? They are provided free legal counsel. The victim is not. I've also heard from mediators who say congressional process is atypical in that survivors don't have the option to be in separate rooms as the defendant's counsel, and that survivors are often addressed in an aggressive manner. Additionally, the fact that House counsel works on behalf of the alleged harasser during mediation and then is charged with advocating to this committee for the settlement agreement on behalf of the survivor seems to be a conflict of interest. If the employee makes it this far, they then have to go through another 30 days of what they call a cooling off period. So now 90 days have elapsed, and that employee is still required to work in that legislative office, or else they're not eligible for services through the OOC. Now, I might also point out at this junction that interns and fellows don't even have this process to access. So they have nowhere to go. After the 30 days cooling off period, then you can either file a formal complaint in a federal district court, or you can have an administrative hearing where there's negotiations, the settlement is approved, and then we move forward. So, for the few survivors who secure a settlement, there is no disclosure of the office involved or the amount of funds. Taxpayers foot the bill, and the harasser goes on with his or her life. There is zero accountability and zero transparency. I might also add that during that process, the victim can't even communicate that they are going through an OOC process to their family, to their friends, or to anyone in their religious community. So it's really no wonder that staffers do not seek this process at all. And finally, as one of them said to me, who I met with last week, I'm a single mother. I can't afford to lose my job. The thought of being blackballed in this institution, the thought of being somehow subject to reprisals, all of that has an effect. So I really feel that it's important for us to move forward, not just with training, but to move forward with a comprehensive reform of the Office of Compliance. Mr. Chairman, I would like to ask unanimous consent to submit the letter for the record of some 1,500 former members of staff in Congress, and I think I've made copies available to all of you. If you flip through those pages, you will see that they range back in the 70s all the way to the current time. So,
Without objection.
With that, I yield back.
Thank you, Congresswoman Speier, for that very powerful and insightful testimony that you've given us today. The chair will now recognize Representative Bradley Byrne for the purposes of an opening statement. We look forward to hearing from you, Congressman Byrne, on your experience to let us know what's happening in the private sector and your time that you spent working on those cases. So the chair now recognizes you for 5 minutes.
Thank you, Chairman Harper, and Ranking Member Brady, members of the committee. I appreciate the opportunity to testify before you today on this important topic. Title VII of the Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, religion, sex, or national origin. In 1986, sexual harassment was recognized by the Supreme Court as a violation of Title VII. In 1995, Congress passed the Congressional Accountability Act, or CAA, subjecting us to Title VII. Based on my prior experience and recent research into the current policies regarding harassment here in Congress, I want to make a few observations and offer some of my own suggestions. First, we need to mandate harassment training. I strongly believe the House should require mandatory sexual harassment training for all members and employees. Recent events have demonstrated that training, while available to members of Congress and employees, is underutilized. I will also note that mandatory training in the House is not unprecedented and is already required for ethics and computer security. There are also multiple harassment trainings currently provided by different congressional support offices. It's my opinion that this committee should settle on one high-quality training product to make sure that all House employees are trained in the same manner. Number two, we should consider a universal harassment policy for all House employees. Although not required by law, creating and enforcing anti-harassment policies is now a near universal norm in the private sector. As you are aware, each individual congressional office is an independent hiring authority, and each office has its own policies. Given the unique nature of House employment, it is my opinion that a universal anti-harassment policy based upon the CAA and applicable to all House members and employees would be much more effective in curbing unwanted sexual harassment than the current patchwork of different harassment policies that we have today throughout offices on Capitol Hill. With a universal policy, the training of House employees would be simplified and made consistent across the House. Number three, we should examine the Congressional Accountability Act and consider improvements to the complaint and enforcement process. It's been over 20 years since Congress enacted the Congressional Accountability Act. I believe this is an opportune time to revisit and consider revisions to this important statute. The statutory provisions governing harassment claims in the legislative branch are different than those that govern private sector employment and other public employees. In the private sector, the EEOC administers and enforces laws against workforce discrimination. The EEOC investigates discrimination complaints based upon a protected class. The process begins by an aggrieved party filing a charge with the EEOC. The EEOC then has the option to request the parties engage in mediation. However, mediation is not required for either party. If mediation is not requested or it's unsuccessful, the EEOC has investigatory power, including subpoena power. After the investigatory process is complete, the EEOC has the right to bring a case upon an aggrieved individual's behalf or to issue the individual a right to sue letter, allowing the aggrieved party to bring litigation. In contrast, the Office of Compliance has no investigative authority and cannot prosecute harassment claims. And the CAA requires mandatory counseling, as Ms. Speier pointed out, for those making claims. We should work to bring the OOC process and authority in line with that of the Equal Employment Opportunity Commission. Other suggestions for revisions to the Act, in my opinion, would include subjecting our unpaid workforce, such as interns, pages, and fellows, to the Act's anti-discrimination provisions. Certainly, these changes will increase the workload of the OOC, and we need to be prepared to provide them the necessary appropriations. Fourth, we need to increase member accountability. Given the constitutional nature of our offices, member-on-member sexual harassment is not something where harassment law and the employment structure can easily be applied. In this matter, it is my opinion that we must exercise our constitutional duty to discipline our own membership. I believe we should adopt a specific policy for this kind of behavior in our Code of Official Conduct, more expressly than one we presently have, that would send a signal that member-on-member sexual harassment will not be tolerated, and that members of this body support those being harassed and reporting these incidents to the Ethics Committee. Moreover, while an employee may be able to obtain monetary relief under the CAA, a settlement or judgment is paid by the taxpayers. Personally, I find this unacceptable. If a member of Congress settles a claim as the harasser or is found liable as the harasser, it is my belief that the member should be personally liable or required to repay the Treasury for such damages. Furthermore, any payment out of the Treasury in response to a claim of discrimination or harassment by House office should be made in a manner that is fully transparent. Finally, it is my opinion that given the inherent power differential between a member and their staff that they supervise, we should include a strict prohibition on members engaging in a sexual relationship with staff under their direct supervision. In closing, I appreciate the opportunity to share my observations and would be happy to provide more information to the committee as necessary.
I want to thank you, Congressman Byrne, for your testimony and with your experience that you bring. And Congresswoman Speier, we want to thank you as well. I know that this is such an important issue, and you've given us much to think about as we go through this review process. So with that, we'll excuse you, and I believe Congresswoman Speier will move up to the dais.
Mr. Chairman.
We'll now take just a moment to get our second panel in place.
Mr. Chairman, the Judiciary Committee has the Attorney General as a witness in oversight right now, so I'm going to excuse myself.
I want to thank our witnesses on the second panel for being here and taking the time to come educate us as we discuss this very serious issue of how we're going to prevent sexual harassment in Congress as we go forward. I'd now like to take a moment to introduce each of you. Mrs. Barbara Childs Wallace currently serves as the chair of the Board of Directors of the Office of Compliance. She received her undergraduate degree from Purdue University in 1973, her JD from Loyola University of Chicago in 1977, and an LLM in labor law with highest honors from the National Law Center of George Washington University in 1979. Ms. Childs Wallace has worked at Carter, Child, and Caraway since 1983 in the field of labor law, giving her 37 years of experience in this area. She also served as chairman of the Labor and Employment section of the Mississippi Bar Association. We welcome you, Ms. Childs Wallace. Ms. Gloria Lett currently serves as counsel to the Office of House Employment Counsel. She received her undergraduate degree from State University of New York and her JD at George Washington University. Prior to serving as counsel, Ms. Lett was a corporate attorney handling employment law issues and litigation for a large telecommunications company. She also served as an assistant corporation counsel representing the District of Columbia in civil litigation, as a special assistant United States attorney for the District of Columbia handling criminal prosecutions, and as an attorney for the Equal Employment Opportunity Commission. We welcome you, Ms. Lett. The committee has received each of your written testimonies. Each witness will have 5 minutes to present a summary of that submission. As you know, to help you keep the time, when I recognize you, the light will be green for 4 minutes. It'll turn yellow for the last minute, red when the time is up. So at this time, the chair now recognizes, for the purposes of an opening statement, Mrs. Barbara Childs Wallace.
Good morning, Chairman Harper, Ranking Member Brady, distinguished members of the Committee of House Administration, Congresswoman Speier, and Congressman Byrne. It's an honor to be here today representing not only the Office of Compliance, but its Board of Directors, which I chair. The other members of the board are Susan Robfogel from New York, Roberta Holtzworth from Illinois, Barbara Kamens from the District of Columbia, and Alan Friedman from California. And we were appointed to these part-time positions on the board by the majority and the minority leadership of both houses of Congress. We're required by the Congressional Accountability Act, or commonly known as the CAA, to each have professional expertise in the application of the workplace laws that apply to the legislature by the CAA. In fact, all 5 of us who are in private practice have decades of experience within the private sector, and a few of us also within the federal government, in both labor and employment and discrimination issues. The CAA also requires that we are to be appointed without regard to political affiliation. Our board has been serving since 1999, and we've worked diligently and in a nonpartisan manner during this time to try and ensure the rights of all individuals working on the Hill, that they are protected. I also want to thank the members of our staff, many of whom are here with me today. The OOC has a huge mandate from the statute, which we accomplish with approximately 20 full-time employees. They're very skilled and equally committed to the tasks laid out for us by the CAA. Finally, I want to especially thank Chairman Harper, who just happens to be my congressman from Mississippi. I'm originally from the Chicago area, but for the past 34 years, I've practiced employment law in Jackson, Mississippi. It's nice to see a neighbor holding the gavel, and we appreciate the fact so much that you have called for this important hearing to take place. As you know, Congress, and has been testified to already, Congress created our office in 1995 under the CAA, which has incorporated 13 federal workplace laws that are applicable in the private sector and the executive branch to the legislative community. This act designates 3 primary responsibilities for our office, although there are many other statutory functions that are performed in addition. First, we inspect the Capitol grounds and the legislative branch facilities to ensure that our community is free from occupational safety and health hazards and is accessible to persons with qualified disabilities. Second, and especially pertinent to the subject of this hearing, we provide an alternative dispute resolution program to covered employees who seek to assert their rights under the CAA. And third, also pertinent to this hearing, our office maintains a robust and comprehensive outreach and education program to this community about their rights, responsibilities, and protections under the Act. In addition, the CAA mandates that our board report to Congress every 2 years on our recommendations for changes to the CAA based on the labor and employment laws in the private sector and in the executive branch. Mr. Chairman, since 2010, our board has zealously advocated in these biennial reports, also known as our 102B reports, for mandatory training on how to prevent and remedy harassment, discrimination, and retaliation of all sorts in the entire legislative community, the sort of training that is regularly performed in the private sector and in the legislative branch, in the executive branch. It is with great satisfaction that we see that this committee and the many lawmakers on Capitol Hill are responding to this recommendation. Before harassment can be corrected, everyone in the legislative community must understand the meaning of harassment, how to respond to it, and more importantly, how to avoid it. Consistent with our statutory mandate to inform and to educate individuals within the legislative branch, our board believes that mandatory training on harassment, discrimination, and retaliatory behavior will provide the best avenue to not only avoid the conduct in the future, but to help transform the legislative branch into a model work environment whereby the lawmakers can and do lead by example. This concludes my remarks, and I ask that my extended statement that has been submitted to the committee be included in the record of this hearing. I now look forward to any questions that you might have, and thank you again.
Thank you so much for your testimony. Chair will now recognize Ms. Gloria Lett for 5 minutes for the purposes of an opening statement.
Good morning. My name is Gloria Lett, as you know, and I'm one of the attorneys with the Office of House Employment Counsel, also known as OHEC. OHEC is basically an in-house law firm available to members of Congress, each of which is a separate employment office, committees, House officers, to provide advice and counsel on the various issues that arise under the Congressional Accountability Act, and specifically, for purposes of this hearing, the question of sexual harassment. We are there as a partner with employing offices to help them understand the issue of sexual harassment and to help them prevent and address the issue of sexual harassment when it does occur in the workplace. I'm very grateful to be here to have this opportunity to talk about my office and the resources that we do provide to House employing offices. OHEC basically has 3 core functions. Those are to provide counseling, to provide training, and to provide representation and litigation when employees raise claims of sexual harassment in their workplaces. The way that manifests itself, and I think it's important to keep in mind that our office is a nonpartisan office. All contacts with our office are confidential, protected by the attorney-client privilege. And so when we are called by employing offices to talk about these issues, I think it's a good model in that they can speak frankly to us, we can ask difficult questions, we can learn the good and the bad and the really bad, and give them advice and counsel on how to address those issues. We talk about the legal issues, but more importantly, we talk about how the office can address issues and take appropriate corrective action to make sure that the behavior stops. That corrective action can range from counseling, sending an employee to training, or discipline up to and including termination. And there is accountability in congressional offices and House offices for individuals who engage in harassment. Sometimes they are indeed fired. The other part of our role is to provide training. We provide training on a request basis. We provide training on a regular basis. The House officers and the IG, for example, schedule mandatory training for all new employees and all new managers. And they schedule that directly with our office, and we conduct that training. We also do training after there has been an issue of sexual harassment. So we go to district offices as a follow-up to make sure that the behavior doesn't happen again. And we do it on a request basis for those offices that are proactive on these issues. We do 3 types of training, actually. One is anti-harassment training that is specifically for employees. Again, that's on a request basis by an office, and we educate employees about what sexual harassment is. That's in-person training. We have vignettes and video where we stop the training at each section and we explain the behavior, and we have a conversation so that employees understand what they've seen and how it can be unlawful and how they can report that behavior to their management so that it can be addressed. We also do something called sensitivity training. The sensitivity training is broader because, as you know, sexual harassment is unlawful under Title VII of the Civil Rights Act, but so is racial harassment, and so is harassment based on an individual's religion. So we discuss those broader issues, but we also discuss sexual harassment in the context of that training. And lastly, we do training for managers. And that training, in my view, is vitally important to be in-person training because managers have to navigate around a lot of issues in order to properly handle the issue of sexual harassment. Not only do they face claims by employees who allege harassment, but they could also face claims by an employee who has been accused of harassment if the office doesn't properly investigate the issue and conduct it in a fair manner. So if someone is accused of harassment and they feel that it was unfair or discriminatory, the result, they can also sue the office. And so we help offices manage that. And lastly, we do represent employing offices in litigation when an employee goes to the Office of Compliance. Sometimes we know that those cases are going to happen because we've advised the office and they've done everything in their power to correct the issue, and sometimes we don't know about it. And so we do represent them and do corrective action in that context as well. Thank you.
I want to thank both of you for taking the time to be here and to educate us as we go through this critical review process and come up with a plan to make sure that we do prevent future cases of sexual harassment, hopefully decrease your workload in the process.